Greetings, everyone. Good evening, everyone. Thank you so much for coming out this evening for our Know Your Right workshop. My name is Benga Ogunjimi. I am the director of the Nigerian Center, and I'm very, very pleased to kick off this event, introduce our speakers, as well as introduce you to the work that we do at the Nigerian Center. The title of tonight's event, Know Your Right workshop, is Green Cards for Minors, which is the Special Immigrant Juvenile Status pathway. If we can please mute our microphones, that'd be wonderful. I just want to give a little bit of a context and background for this event before we get started. This particular pathway, it's one that a lot of people in our community don't know about. And at the Nigerian Immigration Clinic, oftentimes we see families come to the center to do some legal consultation and screening. And during the intake process, we realized they've been in the country as a minor and they could have qualified for this pathway, but nobody gave them this information. And oftentimes it becomes too late to actually transform or change their legal status or reality in the country. So we thought this is very important for the community to know about this. And as we begin to interact with the members of our community or those of us that may come from mixed immigration status family, we all are aware that this is a potential pathway for those who qualify. So we have two attorneys today that will be doing justice to this particular topic. We have attorney Bola Babafemi from the FIBI Law Firm in Maryland, as well as our own April Holloway that will be presenting this workshop collaboratively. But before I turn it over to the experts, I just want to take 1 minute to tell you about the Nigerian Center. I just want to apologize in advance if you've watched this video many times. Let's just give the benefit of the doubt for those who have not.
It's Nigeria, what moves in Nigeria? And then yeah,
and I'm the founder and executive director of the Nigerian Center. The Nigerian Center is the very first Nigerian American immigrant and community center. While we are called the Nigerian Center, we serve all minority and all immigrant groups in the United States. In many immigrant communities across the country and around the world, whether they're Chinese or Jewish or Latinos or even Ethiopians, there is an actual location members of those communities can walk into to support the American dream and American experience. While the Nigerian community individually has prospered, we now have an opportunity as a community to have our own Nigerian Center.
I am most excited to be a part of the Nigerian Center because we are a resource hub. And we know that while a lot of Nigerians we may know come into the country and they have a connection here or there is a huge population that don't have access. I can speak to thinking about maybe 30, 40 years ago when my parents came to the country. And while my dad came to the country through education, my mom came through a lottery. And when she got here, she had to go do things a regular way. You know, she came in New York, hustled, worked at McDonald's for like 2 weeks. And from McDonald's, she started getting, other menial jobs before she was able to meet my dad. They got married, they had children. My mom didn't go back to school until she was like 40 to finally start her career. And I know that if there was something like the Nigerian Center, She could have been afforded opportunities, access information on how to go to school or how to start her own business if that's what she wanted to venture into.
I remember my uncle, I think I was like 10. He got deported. I haven't seen him in years because he can't come back in this country. If he had had the resources that the Nigerian Center offered, maybe it would be a different story.
As a pastor, and I can speak confidently for the church community, a lot of pastors struggle with the kinds of immigration challenges that their members are having. And sometimes when we pastors meet, we joke about the fact that there's this thing that is, the don't ask, don't tell kind of thing, principle that most Nigerians are engaging in. They don't tell you what they are going through. Some of them are dying in silence. By the time they speak up, sometimes it's too late. And I know that as a pastor, I could have, the Nigerian Center will have come handy in helping people to know what is right, having the kind of the right information, speak to the right attorney, have right representation in court, and just to make the journey easier and smoother in the United States.
People come here from different paths and for the same main reason is to get a better life, a better situation for their family. So there are numerous ways, numerous paths to the United States and to citizenship. So we help people with family-based immigration, employment-based immigration, asylum, refugee cases, student visas, pretty much everything that the law allows us to assist people with the process of immigration.
Just having the center here, is just people identified that looks just like us, who we can get the resource from. I mean, this is something that even me as a grown-up young person just wanted to come. I wanted to know that it belongs here. I'm just happy that this is here. I wish that my mom and dad, they were still alive to witness this experience.
From the time my parents came from Kenya, they immigrated to New Jersey. That's where they actually met. It took years for my mom to find employment. My dad has stayed at the same job for 25 plus years in fear of not being able to find other employment. Not even that, being able to purchase a home, it took them 25 years to buy their dream home. Having the healthcare aspect and having health insurance for my siblings and I. Nigerian Center is providing a service from all crosses across the board for immigrants.
And Nigerian Center provides opportunities with immigration and naturalization, provide home ownership opportunities, access to capital, language classes, and cultural programs.
Learning about the Nigerian Center was a godsend. Growing up, I used to think about how we can share our experiences and our culture. And oftentimes, Nigerian people are so interested in giving back, but there are few opportunities and motives to do so. So when I heard about the Nigerian Center, it just clicked. We're talking about home ownership. We're talking about financial literacy. We're talking about immigration services, not only for people from our background diaspora, but for everybody else as well who can gain from it. I see the Nigerian Center not only as an opportunity to celebrate our culture, but to also share it as well.
I welcome you to be a part of the journey and to be a part of the experience. Welcome to the Nigerian Center.
Okay, so I want to go straight to our upcoming events that we have coming up. July 7th, we have a community meeting that will give us the opportunity to talk about our 2024-2025 strategy, progress report, and engagement opportunities. If you want to get more connected to the work we do at the Nigerian Center, if you want to learn about our plan, our strategy, opportunities to critique it, give us your insight, your feedback, and to be deeply engaged in the work that we do. This would be an opportunity to do so. Our entire team, our board, our community will be there. It's a virtual event. The information is already on our website if you want to register for that. And also want to just a little bit talk about more opportunities to get involved. This recording will be on our YouTube page. as well as the previous recordings of our Know Your Rights series. We have a library of Know Your Rights contents from family-based, employment-based, humanitarian-based immigration, work authorization, even policy that is more recent and affects our community. You can see all of that on our YouTube on-demand page. You can go through media to get them. Volunteer opportunities, we just updated our volunteer list on our website. So if you go to nigeriancenter.org/serve, you can see opportunities that we have to get involved. We do have a community partners network. It's not limited to Nigerian organization. Any and every community-based organization, whether they are media, faith-based, community-based, we welcome you to join our community partners. It's a very short form that you can fill out on our website. If you're not following us on social media, please do so today. We are active on Facebook, Twitter, LinkedIn, Instagram, and YouTube. Our handles are Nigerian Center or the Nigerian Center. Speaking opportunities, if you want to present a subject matter of expertise, area of expertise you may have, you think is beneficial, or nominate someone who can complement the work that we do, please fill out a form and reach out to us for that as well. Lastly, I want to talk about donation opportunities. If you're not currently supporting Nigerian Center, please make a commitment to do so today. Nigerian Center is a volunteer-led run team. We rely on your contribution to do the important work that we do. And I really want to encourage you to not wait till you can make a significant contribution. I often say the best way to support the Nigerian Center is through a recurring donation. We are 501c3. Our donations to us are tax deductible. Please support Nigerian Center. Your resources can go a long way. You also might have received a request that we put out for a member of our community. We did get some feedback that we should have spoken more about this particular need. It was an individual who came to the immigration clinic, and I've made a decision to go back home because of significant challenges they are facing, including homelessness. We put out that letter. If you want to support that campaign, you can make a donation as well. Okay, thank you so much for your patience. At this moment, I'm so pleased to bring our first speaker, which is going to be Miss Bola Babafemi, to please come to the microphone. She's from the FIBI Law Center in Maryland, and she's also a member of the Nigerian American Lawyers Association and a great supporter for the work we do at the Nigerian Center. Over to you, Ms. Bola.
Hello, everybody. Can everybody hear me clearly?
We can hear you, but we cannot see you.
Okay, so I'm going to briefly show my face. Today has been a very, very busy day. I'm kind of sleepy, but I'll try my best to be coherent. I'm not sure. Can you see me?
We're almost there. Can you tilt your camera a little bit down a little bit? We see you. Excellent.
Okay. All right. Okay. So I'm gonna say good evening, everybody, again, and thank you, Mr. Benga, for what you do at the Nigerian Center and for this opportunity. I appreciate the opportunity to speak on this platform. I'm not taking it for granted. And also to Miss April, I'm saying hello. Thank you for having me. Thank you for having me. So we're going to be talking about the Special Immigrant Juvenile Status, and you're going to be hearing me say SIJS a lot of time. That's what that means. And the applicable law is the Immigration and Nationality Act, and also SIJS is like an hybrid program between the state juvenile court or family court in most states, and the federal agencies. So it's like an hybrid kind of process between both departments of the state and also the federal government, which is the USCIS and the rest of them, the Homeland Security, depending on what's the status of this particular juvenile that we're talking about. So that being said, again, my name is Bola Babafemi, and I'm with the FIBI Law Center here in Maryland. We practice immigration, we do family law, and also we do personal injury. So today I'm going to quickly try to be brief, because basically there is about 3 stages that is very important when we are talking about SIJS. You talk about the initial stage where you talk about the custody and the predicate order, where you get the order from the state's court on the determination of dependency of that and the best interest of that individual. And we also talk about the second stage, which is when if you get that approval and you cross over from that stage, you go to the stage where you file your I-360, and that is approved. You then go to the stage where we talk about getting adjustment of status once you become active, once your visa becomes current. So I'm going to be talking about the custody and the predicate order, and then Miss April is going to be talking about once you get that predicate order and a valid predicate order from the state court, she's going to be talking about the I-360 and also the I-485. So just so that everybody understands what SIJS is, I'm going to kind of try to start with a brief background into what SIJS is. Generally, we know that when we're talking about immigration benefits, we have different categories. Sometimes you want to go by the family-based petition. You want to, there's another category that is the employment-based petition, and other categories like the humanitarian-based, which is something like asylum, SIJS, the T visas, the U visas. So SIJS is under that category of that humanitarian benefit, that relief that you can seek from USCIS. And SIJS is basically for certain category of people. And when we say SIJS, what is SIJS? What do we mean by SIJS? It is a form of humanitarian-based relief that is for non-citizen children who are within the United States and who have suffered parental abuse, mistreatment, or abandonment. And for these children to qualify, these children have to meet certain requirements. Like for instance, they have to be children that are under foster care or living with one parent, or children who were abandoned already. Also, those children have to meet certain requirements according to the standard of federal law. You have to be under the age of 21 to be able to seek that relief from the immigration, and also from the states that you are. You have to be on that. So basically, when you are an immigrant in a state, when you are a minor under the age of 21, and when you are a child who has suffered a form of abandonment or abuse from either parent or both parents, you basically qualify for this. It doesn't matter whether you were inspected, whether you came in through the port of entry, or you were checked at the port of entry, or you came in through without being checked, and then you were placed in the custody of the DHS or ICE. It doesn't matter, as long as you meet this category and then you are able to follow the steps that are outlined, then you are able to qualify and benefit from this relief. So what happens, what do we see? What we see is that in our community, like Mr. Benga rightly said initially, we realize that a lot of people are not aware of this. They're not aware of this information. And you see a child that has been here that should have qualified. Now they are 21 or above 21, and then you ask them about when they've been in the country, and you realize that they let all those years waste away without taking the right step. So now that we have established what SIJS is, we established that SIJS is a form of humanitarian benefit for non-immigrant children that are within the United States, that are under the age of 21, that have suffered some form of abuse or abandonment or mistreatment from either parent or both parents, and as long as they can establish that act of abuse happen before the age of 18, then they can seek this requirement. Also, they have to be unmarried. So the eligibility are that you are unmarried, that you're physically present in the United States, that you are under the age of 21, that you have consent of the DHS. That is if the child is not with any family member or with a guardian, appointed guardian, or with any guardian that is appointed by the juvenile. So some of these children, once they cross the border, they're placed in DHL custody. In that case, DHS have to give consent. But if you're just with maybe a family member, a guardian, then you don't need the consent of the DHL. You also need the valid court order. That's what we call predicate order. That's where we see the intersection between the state's juvenile court or family court and the agency, the DHS or the USCIS, as it may be. That's where you see the intersection. This state court must have jurisdiction over this child, or the beneficiary or the potential applicant. And that jurisdiction has to be continuous, meaning that a child that wants to get a predicate order from a state court has to be in the jurisdiction of that state court. So if you're in Maryland, you cannot approach Virginia court, or you cannot approach a court in DC or a court in New Jersey to give you a predicate order or to give you that valid order that you need to apply for your SIJS status. So that determination has to come from a state that has jurisdiction, and it has to be, what we mean by that is just in the state where the child lives. And also the child must be in the custody of a court-appointed guardian or one of the parents. Could it be one of the parents? The abuse might have been from just one of the parents. And so it doesn't mean that because you're still living with one of your parents that you can't file. As long as you're with that parent and that's not the abusive parent, or with a family member, you can still go ahead and apply for that. So what we're talking about is the state courts will have to make jurisdiction determination regarding custody and also the predicate order. Now, the custody is, they have to say you are under the care of an individual who is appointed, like I said, or by court or by the juvenile herself or himself. And once that is done, the courts will also have to make determination regarding the best interest of that child. They have to make determination regarding the dependency and custody, and they also have to make determination regarding parental unification. Basically, eligibility for SIJS is predicated on that decision, and I guess that's where the word predicate order came from. It's actually predicated on what that state juvenile court determination is, whatever it says. So you can't even move forward to apply for SIJS status if you were not found to be eligible, or that order from the state court is not valid, or if it's not, if you don't have that order. So that's the first stage you have to cross. Now you determine that you qualify for SIJS. What do? You have to approach the court, and the court has to determine on custody and also determine that your dependence on custody, that you qualify. And in this order of the court, for it to be valid, you have to look out for certain things. That order will be valid if there is custody and dependency determination. That order will be valid if there is parental unification determination and also best interest. What are we saying? Dependency and custody would declare that petitioner or that beneficiary or the juvenile in any case to be legally dependent on the court, or to be committed in the custody of any of the people we have mentioned, in maybe a family member, a parent, or guardian, or a state agency. And also it will declare that that child is dependent on the court, or declare that child has to be in the custody of someone. So that's the first step. The order has to also state that parental reunification is not possible, meaning that this child has suffered so much, or maybe so much mistreatment or abandonment or abuse from a particular parent, maybe one of the parents, in such a way that it is impossible for the court to, in good faith, says, oh, go back to this person. So it is the court has to make that determination that this person can no longer be reunited with this abusive parent based on the fact that is presented before the court. Also, it has to talk about the best interest of the child. The court has to declare that, you know, after reviewing the documents and the evidence before it, that it realized that it should not be in the interest of that child to be forced back. So for instance, if a child is here and the abusive parent is in Guatemala or is in Nigeria, the court will find that determination that it is not in the best interest for the United States to say, hey, go back. We're taking you back home to meet this parent. So all of those very crucial determination has to be made in that predicate order. So usually you will have to work with an experienced attorney to get you through those stages. So once the custody, dependency and custody is established, and then the parental unification is established, and also best interest is established, and also in the case of children that are in the custody of DHS, consent also have to be obtained. That means your attorney or your guardian, they have to work, and your guardian has to work with DHS to get their consent. Usually, if a child qualifies, DHS would not hold back their consent. They're not going to say, hey, no, we're not giving it. If they qualify and you present your case before them, they would give you the consent. And if all of these ingredients are present in your predicate order, then that order is valid. So once you get this order from the state's juvenile court or from the family court, of the case may be, then you can then move forward to apply for, because that's your eligibility has been determined, and then you can then apply for your I-360, which is the application that you need to file to get approved as a special immigrant juvenile status. So you have to do that. But one of the things that I must say is that when a child is applying to a state court, there has to be continuous jurisdiction, meaning that you cannot be applying with a state court and then in the middle of the case being decided or the order being determined, you moved state and you're going to another state. So all through the process of you getting your predicate order, you have to be in continuous jurisdiction of that state court that is going to be giving that order. So you can't just move between you can't just move between the time that you have filed. You can't say, I filed the order, now I'm moving. The courts have to have continuous jurisdiction over that child up until that order is determined. Also, one thing that I have to talk about is the federal law, the Immigration Nationality Act, talked about the child has to be under the age of 21. Now, in Maryland, for instance, Maryland and the Immigration Act, Nationality and Immigration Act, talks about the same age. If you're in Maryland, you say, because it's the same determination, it's the same rule I say, the category, the definition of being under the age of 21 is the same in Maryland as this with the federal. So you're good. But if you're in the state, other state, there are states, I know that Virginia in the past, I think that I'm not sure what the status is in Virginia right now, but in the past, it used to be that in Virginia, the conflict is that a child files and initiate that order before the age of 18. So they're good. Now, because of delays and backlogs and things like that, a child is in that process and they are now over the age of 18. Now, maybe they're now like 19 during the time that they're trying to get the final determination. And also you must realize that a lot of time, this person, most of this abusive parents are always out of the country. I'd say 60 to 70% of the time. So sometimes it takes a longer time for you to even get to serve this person and for you to even get the process started, even though you initiated it already, for you to keep it moving. It takes time. So sometimes you see a case where a child starts, or they initiate the predicate order in a state, juvenile court or family court, and before the age of 18, and now they are almost 20, and the case is still ongoing. Some states, once you are above the age of 18, there's this conflict that you cannot, even though you have up until the age of 21 to apply for your SIJS status with USCIS, but some states cut off that age from 18, meaning that for you to be considered as a minor in some states, you have to be under the age of 18. So once you are above that age, some states will cut you off. And now you are caught in between, oh, I'm still supposed to be qualifying for this, but because I'm living in this state, I've been caught up because of my age. So in those kind of cases, there is really nothing to do other than if you know that you really want to benefit or you can benefit from SIJS status, you have to look for a state that would allow or that would include, that will not exclude you or cut you off as soon as you're 18. Because a lot of time, it takes time. So you need to bear in mind that order must be initiated in court before your 18th birthday. That is very key. And for states like Maryland, as long as you initiate it before the age of 18, you are still safe as long as you're not above 18. But for some states, once you are above the age of 18, you won't be able to even initiate that order in that state court. So you have to really find out what is applicable in your state so that you know if you're still safe, and if you're 19 and another state will allow you to initiate it because you're still under the age of 21, you probably have to consider changing jurisdiction and maybe moving and changing to that state. Now, we have talked about all of the factors that the court will consider and the determination that has to be made. Another thing that I also need to say is that people need to know that once they apply for SIJS, or once they get the benefits from SIJS, immigration benefit status from SIJS, that kind of a child can no longer file for any of the parents. It does not matter. Now you become a citizen afterwards, you cannot file for any of your parents. Those parents can no longer benefit under you. Any other person can benefit under you, your wife, your spouse, your child, but the parent cannot benefit under you. Now, it doesn't matter whether, it was the father that abused you, but the mother didn't abuse you, so your mother should still be able to qualify. It doesn't work that way. So once you take that route, you won't be able to file for any of your parents. It doesn't matter whether it's the abusive parent or the non-abusive parent. So we have to have that at the back of our mind. No, so now, once you are gathered and you are equipped with your predicate order and custody and predicate order from the state's juvenile court, then it's time for you to move forward. That's when you would now move forward to the state of applying for your I-360. Now, I need to state that the fact that you have received your predicate order from the state juvenile court does not guarantee that your I-360 will be approved. You still need to work with an attorney to make sure that every other thing is done right. So, but it's a big giant step towards your ability to apply for your SIJS status with the USCIS. I think that's about it with the predicate order. And if there is any question that anybody would like to ask me, I would be willing to I'll be willing to answer. And if there's anything that I happen to leave out, I believe Ms. April can call my attention to it. So I'm going to yield my time now to Ms. April to talk about the I-360 and I-485.
So you have a question in the chat. The person says, I'm 20 in Maryland. Can I still start the process?
Are you 20? Are you already above 20, or how far away from 20 are you, and how close to 20 are you?
Hi, I'm the one that asked the question. I turned 20 2 days ago.
Yes, you can still, because the state of Maryland, usually you say that before the age of 18, but the state of Maryland, to the best of my knowledge, has not strictly been saying you can't initiate that order after your 18th birthday. They kind of align with the federal government that says that before the age of 21, you can apply. So I would say that you still have a shot. But the point is now, if you clock the age of 21 while that is going on, that might be an issue. If you don't get the process, all the process done, remember that I said that I talked about the process that it takes for you to even get the person served, the other person, and all your documents together. So if you now clock 21 before that determination is made, that's where the challenge will be. But if you're able to speed through the process and get that determination before the age of 21, you can still file. There are some times that some immigration, some local USCIS office would even allow you to come in, and sometimes they allow individuals to come in and submit that application if they are very close to their 21st birthday. And if it's going to cut them off, if they want to go through the usual route, sometimes they allow in person, and they will allow you to come in and drop in your application. So the issue is we have to think about, are you still going to be able to make and get that order before the age of 21? If you're able to do so and you are still under the age of 21 before that order is issued, yes, you can still apply and initiate that order in the Maryland court.
Okay,
And
thank you.
next question. Oops, sorry, go ahead.
I was just saying thank you.
Oh, thank you. The next question is, if you reunify with one parent but not with the other, can you still apply for SIJS?
Yes, like I said, remember I said that sometimes that child may even be staying with one of the parents. So it might be that you're here in the US and your mom is in the US, and maybe you're living with your mom, but you were abused before the age of 18. And that's a key thing. That abuse must, and then for the last person that asked the question, I want to believe that you can establish that that incident of abuse happened before your 18th birthday. That is key. So even though you are now filing, but that abuse must have happened before your 18th birthday. So if that's the case, and then say your father was the one that abused you in Guatemala and you're here with your mother can still be your guardian. And you're still, you're unified with your mother, but the abusive parent is the one you can be reunified with. But yes, if you're with one parent, as long as that parent is not the abusive parent, because if it's the abusive parent, you can't still be staying with them. So if that parent is not the abusive parent and the other parent is the abusive parent and you're living with that parent, that one parent, you can still apply for your PCI status.
All right, you've got
I hope
another
that answers your questions.
All right, you've got another question. My son, who's 18, I see from the other comment, has just been admitted to college but is undocumented. What can we do about? So I already know, in order to answer that question, she's going to need to know, is he living with both biological parents, or has he been abused, neglected, or abandoned by one or both parents before we can say whether or not this would be an option for him? So go ahead and put that in the chat, and then we'll come back to your question. Next question, what's the difference between abuse and abandonment?
Okay. Well, the law didn't say that one is exclusive. It could be, the child could have experienced either or. So some children, abandonment is, for instance, say some parent, I think I've heard these instances before. Some parent came maybe from Ghana, for instance, and they came maybe as a family on holiday or something, and then they came to maybe a family member, and as if they came in as for an holiday, and then all of a sudden they're leaving and they just left the child behind without any forwarding address, without telling the person they came to visit about anything. Maybe they just thought, oh, he's in America now, I can just abandon him. And then they went off without looking back. That's abandonment. You don't leave your forwarding address. You don't tell anybody anything. That's an example of abandonment. Now, abuse is different. Abuse could be physical abuse that you have suffered. It could be mental abuse. It could be torture. It could be any kind of mistreatment from one of the parents. So that's the difference between abandonment. Someone who is abandoned is not literally physically abused, but if you look at it in one way or the other too, that's devastating. It is devastating for any minor child to realize that all of a sudden I am parentless, if there's any word like that. They just came in and just dumped me and I'm here. That's psychologically, I don't know. it's not good. It doesn't make anyone feel good. So that's the difference between abandonment and abuse.
I'll just add to that. One thing that we do also see culturally is that a lot of times people leave their kids with an aunt or a family friend, and the intent is you're going to go to school in the US and you're going to have a quote unquote a better life. Well, that's considered abandonment as well. Even if you leave your child with good intentions, the fact that you left them is considered abandonment. So you can still be a loving parent who has abandoned their child.
That is true.
Okay. So there's one question pending. Once we get the extra information, we'll come back to that question. If you're able to stay on standby for that one.
Yeah, that's okay.
All right, perfect. So we're going to go on to the I-360 and the I-485. Jump in anytime that you have some stuff that I might miss. So the I-360, once you have your custody order and your predicate order, your very next step is to submit this form I-360. This form is a multi-purpose form. You can use it for Amerasian, Iraqi nationals, widowers, people who've been abused by their US citizen spouse or child, and it's also for special immigrant juvenile status. When you file this form, you are asking for USCIS, United States Citizenship and Immigration Services, to officially designate you as a recipient of special immigrant juvenile status with all the benefits that comes with that, okay? This has to be filed before you turn 21. So for the young lady who was turning 20 or just turned 22 days ago, if you are able to get your custody and predicate order before you turn 21, but then it's 2 weeks before you're about to turn 21, you don't submit this by mail. You submit it in person to USCIS because they have to accept it before you turn 21. If it gets mailed and it gets rejected, it's not accepted. Okay, it has to be done before you turn 21. So in order to file the I-360, you must be present in the United States, so you can't leave, okay? Once you get that custody and predicate order, you can't leave the US and go traveling anywhere. You must be present in the United States. You must be unmarried and under 21. If you get married, you are no longer a dependent in the state court. Your custody order and your predicate order are no longer valid if you get married. So you have to stay unmarried. And we already discussed you have to have the custody order and the predicate order. One thing I want to touch on about the predicate order is a lot of times people think they're going to save money by not having an attorney and going to get the custody order themselves. That predicate order requires special language. And if you don't have that special language, the custody order is useless. So that's one of the reasons why you really want to use an attorney for this process. All right. Give me 1 second, going to chat. Okay. All right, there's information. Okay, so I already covered this. It has to be filed before you're 21. Just want to put emphasis on that because if it's not, then your custody order and your predicate order are useless, okay? When you file your I-360, what do you need to file with it? You need to file your birth certificate because you again have to prove that you're under 21. If you come from a country that issues multiple different kinds of birth certificates, or if you are issued a late birth certificate, then you need to look up the standards of what kind of birth certificate is required for your country to be sure that it's not going to be rejected. You need to include copies of the orders from the court, the custody order and the predicate order. And right now the filing fee is $0. You will double check before you file because the filing fees do change. And this is the form I-360, okay? Now, a big question people have is when you're designated with special immigrant juvenile status, can you get a work permit? Well, there is a current temporary rule that allows for work permits. This is not the way that it always was. Before, you just had to wait until you applied for residency. But right now, you can apply for deferred action, And when your I-360 is approved, they automatically send you a letter saying that you've been granted deferred action, and you can file for a work permit under category C14. And again, right now, the filing fee is $0. Just double check that before you file, because those do fluctuate. That temporary work permit is one that you would be able to renew for as long as you are waiting for that I-360 priority date to come current. What is a priority date? On your I-360 form, it's going to show the date that you filed it, and then it'll have another date that's very close in time to that says priority date. That priority date tells you when you're going to be able to file for residency. So I'm going to go out of here for a second. Yeah, okay, did it. And show you the visa bulletin. So this visa bulletin gets published every single month, and it tells literally how many visas are available in every category in the US. So this is the visa bulletin for 2024. And if you scroll down, you will see this category here, certain special immigrants, okay? And then you go here, and these dates tell you what is current for the fourth category, which is special immigrants. This means that people who applied on January 1st, 2021, that have this priority date, they are currently eligible to file for residency. So you would have to wait until that date matches or is beyond your priority date. And at that time, that's when you can file for residency. I want to start from here. I think I have to start from the beginning, and then we'll just click through. Sorry. I just wanted to show you how the visas work. And sometimes we can kind of guesstimate how long the wait is going to be, but because Congress allocates these visas, the number that are in each category, it does sometimes jump from time to time. And it also depends on how many people are using them. Everyone who gets an approved I-360 doesn't always apply for residency. So it just depends how many people are using them. Some very, very important reminders. Once you get your approved I-360, the current rule is that you can get married. The prior rule is that you could not get married before the I-360 was approved. My recommendation to you would be to wait until you are a resident to get married, okay? Because that rule, just like it just changed just now, it could change again in the future. So best practice, wait until you are a resident to get married. Also, criminal activity can disqualify you from residency. So you don't want to have any interactions with the police, no matter how minor. Don't speed, don't drive without a license, no matter how minor. Avoid any interaction with police or criminal activity that is going to make it so you cannot use that approved I-360 to obtain residency. Marijuana is not legal for you, okay? Immigration law is based on federal law. So even though there are some states where marijuana use is legal, you are under federal jurisdiction as an immigrant. So if you are caught in possession of marijuana, that is going to be held against you in the immigration process, regardless of what state you're in, okay? Marijuana is not legal for you. And then the last thing to be, there it is. There are some cultures, I work with a lot of people from different places where it's very common, normal, and accepted to have a relationship with someone who is much younger than you, okay? In the United States, that is considered statutory rape, okay? So if you are 21 and above and your girlfriend is in middle school, she's not your girlfriend anymore, okay? You can't do that here. Statutory rape, relationships with minors will disqualify you from residency. And you cannot use your culture as a defense, okay? So just, these are some resources that the Nigerian Center has We do free consultations every Thursday if you want to get more detail about what you're eligible for, whether that's special immigrant juvenile status or something else. We also help with reviewing your applications if you're filing on your own. If you're going into an interview for a spousal visa or for citizenship, we can help prepare you for that. If you're applying for asylum and you want some additional evidence to help with your asylum case, we have state reports and evidence specific to Nigeria on the website. We also have previously recorded seminars on TPS, Congress, work authorization, humanitarian visas, and other subjects on the YouTube page. So now I'm going to stop screen sharing. So anyone that has questions, you can put your questions in the chat, or you can go ahead and unmute yourself and ask your question. I feel like I talked way too fast. So please feel free to tell me anything that I didn't cover or that I left confusing.
Quick question.
Yeah.
I'm sorry.
I just want to add one thing really quick, Benga. I forgot to add that when you apply for residency, you can also apply for travel authorization. So that would be the first time in this process where you're able to apply for travel authorization, and you can leave the US and come back once you have that.
I don't know if this question has been answered, but my son has just been admitted to college, but is undocumented. What do we do about living with his mom?
Okay, so if there, you know what, I'm going to let you answer that question.
Yeah, I think what you the questions that you asked were very valid, just to find out, like, is the child living with both parents or with just one parent? So we wanted to find out that, because that would make a huge difference. If the child is living with one of the parents, yes, the child, and then the abuse or abandonment happened before the 18th birthday. Yes, even though the child is 18, and because it's in Maryland, it can still initiate that order. There's some states that would cut you off once you're 18, like I said. So I'm just saying, so that should answer that question. So the parents should know that, because some children are undocumented, but they are living with both parents here. So if they are living with both parents here, there is no case for abandonment or abuse or anything of sort, except there is a very valid case to show that one of the parents now abused them and they're not longer living together. So that's the point, because remember we talked about determination has to be made that reunification is impossible. So if you're not living with both parents, it looks as if that kind of, what will I say, that kind of override that determination. That means the court won't be able to find that determination. So I hope that answers that parent question. If your child is 18, is in college, it doesn't matter if he's living with you alone. And if the abuse or abandonment happened before 18th and is in Maryland, it can still initiate that order. But if it's living with both of you, then the finding of abuse or abandonment, I don't know how that would be possible.
Does non-payment of child support constitute abandonment or abuse?
Well, I don't, and Miss April can weigh in on this, but I would say that not paying child support is, I don't think that necessarily alone can constitute abandonment. If the marriage is, maybe the parents are no longer together and is one of the parents have primary custody of that child, if the father is not paying child support alone, I don't think that alone can be a good ground to find that abandonment, because it could be any reason, and that's a different charge on its own. So I wouldn't think that the courts will basically just find that determination based on the fact that the child, the father is not paying child support. And it's always good for you to use your strongest link rather than you just going, and if you don't really have a very good evidence to put before the court, most times the court would want you to see to bring all this evidence before them. But I'm going to let Miss April weigh in. Does not paying child support alone, would that qualify for abandonment or abuse?
Alone, no. There would have to be some additional factors. No visitation, unsafe visitation. There'd have to be some additional factors besides just failure to pay child support.
Okay, thank you for that. I just want to say, So once someone initiate this process, does the state initiate a legal action against the abusing parent? That might be a deterrent for someone to proceed. But either way, would the state take up action against the parent?
Independently.
Yeah, I don't think so. And like I said initially, most of the time, the children that I've dealt with, the abusive parents is most of the time, I'll say 99% of time for me is out of town, like out of the state, out of the United States, most of them that I've dealt with. So it's for the states to determine the eligibility just for the benefit of the child. It's not in their place to go out of their own way to start initiating that abuse. Well, if a parent wants to initiate that, then they can do that on their own on behalf of their child, or if the guardian wants to do that.
Yeah, the most severe thing that I've ever seen happen to the other parent is if there was an outstanding order of child support, the IRS might seize their tax return. That's the most severe thing I've seen happen.
There is Mr. Olanike. I don't know what question is asking. Let me see the chat.
What if well, there's one before that. Do you get a state ID once you've filed for an I-360 form? So every single state has different policies on what it takes to be able to get a state ID and to get a driver's license. Every state is different. Okay, in DC, you would be able to get one, but every single state is different. And you know what? Different branches within the state will sometimes operate differently too. What about if the abuse didn't start before you were 18? So if the abuse started after you turned 18, I think he's asking if you can still get a custody or predicate order.
Well, the rule that as far as I know today is that incident has to happen before the age of 18.
That's my understanding as well. This question has come a couple of times, so I feel like maybe we're missing exactly what you're asking. If a child is living with both parents, can they still file for juvenile? So they have to be abandoned, abused, neglected by one or both parents. But because it's the questions come up a few times, I feel like maybe there's something that we're missing. If it's both biological parents, then the answer is no. But is there like some other complicating factor that I'm just not understanding? Do you have a different answer?
No, I don't have a different answer, because the thing is, it's a different thing if the child was living with both parents and maybe one of the parents discovered the abuse and they moved away and now is living with one of the parents, then you can start that order and say, yes, we were living with this parent, the abuse started and then the mistreatment made us leave and now is with one parent now. But like I said initially, it's to be able to, the court has to have evidence. Something has to be presented before the court to show either that mistreatment, abuse, or abandonment before they can make that determination. So you really have to show them. Now, it's difficult for you to show that if the child is living with both parents. How can you, in good conscience, say that you're still living with that parent that is abusive? It's like she said, except there's something you're not really coming forward with.
So what can you do? Let's say that situation that you just said did happen. One parent discovered the other parent is being abusive and has moved away from that parent. What would the steps be that you take in order to start working on getting a custody and predicate order?
Well, first of all, we shouldn't forget that abuse must have happened before 18. So that it has happened before 18, that child is undocumented, that child is now staying with one parent. So it will the thing to do is to approach the court. You could work with the lawyer, that's advisable, like Ms. April say, for custody. So court has to find that determination of that custody. That parent will now be appointed, because the juvenile has a say. If there's somebody that is available to be your guardian or your custodian, the court is not going to say, oh, we're going to appoint a different person. So that parent would definitely be appointed as your custodian or your guardian. And then the next thing to do is to, based on the evidence that you have, present your evidence to get that that order. Now, that you're not living with the father again, or you're not living with that abusive parent again, it will be difficult. That's still considered abandonment. And because the chance that you have in this case is because it says both or one of the parent. So it's one of the parent that is considered to be abusive. So you have to just move forward to get the custody and initiate the predicate order, and then bring all the evidence of the abuse that you can find or that the parent has been able to discover or show. And then with all other things being equal, it's most likely the state court will definitely be able to find that that determination, especially if it's not in the best interest of that child to ever be reunited to that father. Even though maybe the father is still, I haven't had that case before where the father is living within the same state and a parent is filing for this. I haven't had that particular case, but I believe that I don't think that would deter the state from finding that determination, especially if there is a strong proof of that abuse, to say that you still have to present that case before the court and the evidence before the court. I believe that with a strong evidence of abuse, they may be able to find that that child cannot be reunified with that parent. And another thing that parent that is now, presenting this case on behalf of the juvenile should know is that even herself, she can no longer benefit through that child. So assuming the child went ahead and got approved and also became a citizen, a parent can no longer benefit under that child. So you have to think about all of that ahead of time before you take the step towards it. So I believe that you should still be able to get, especially if there is a strong evidence of abuse by that parent.
Now, what would you recommend to, we might have one in this room, or we might have someone watch on the YouTube. You are a 15, 16, 17-year-old child. You were brought to the US and left in the care of an aunt or an uncle and bounced around from place to place. What do you do if you don't have a guardian who can take custody of you, but you are otherwise eligible because you've been left in the US alone?
Yeah, you will still, the state can appoint a guardian. It doesn't have to be somebody that you know. So the first thing is to find where the right place, like Nigerian Center, or find an attorney that can help you. And then when that is established that you qualify, the attorney will definitely point in the right direction. You can approach the court. You don't have anybody, but the court can definitely appoint a guardian for you. If you qualify, the court will appoint a guardian for you.
Okay. There's another question. So what if both parents are trying to come back together and the child has already filed for juvenile status? What would happen to the case?
Well, this is like medicine after death. Because if it is established that the child, at the time that he or she filed for that status, qualifies, and the case is still pending, and the judge has all that it needs to find that determination, it doesn't matter what the parent are now trying to do. That's now after the fact. The issue is, was there ever abuse or abandonment at a certain time before the 18th birthday of this child? Yes. If that is checked and the child qualifies and initiated that predicate order and custody and predicate order before the cutoff time, maybe before the age of 18 in those states, or before the age of 21 in those states, it doesn't now matter what that parent, the parent of that child, is now trying to do. Whatever they're trying to do does not have anything to do with this child, except the child now wants to withdraw his own case because his or her parent is trying to come together. Otherwise, if the child is not willing to, and it qualifies and the eligibility or determination is made, I would say go on and do your thing, and your parent can still come together if they want to. It's not predicated on whether your parent is still together or not.
Okay. Benga, did you have another question?
Yes, two questions. If someone becomes a guardian, is there a required amount of time the minor has to live with them? Is there a residency requirement before they can proceed with that predicate order application? And number two is, we see cases where people are reluctant to proceed even though one of the parent concerned is overseas, with the fear that it might jeopardize their ability to be able to return to the US. So does initiating this juvenile status affect parents' ability to return back to the US? And first question. Second question is there a required amount of time the guardian and the juvenile has to have some kind of living or relationship?
Well, to the best of my ability, the first question you asked, you said, is there a requirement of residency? No, there is no requirement of residency. The guardian doesn't have to be documented even. Let me put it that way. I have seen cases where aunts, sisters who, for this, a lot of Spanish people that I've dealt with, aunts and sisters themselves would not have documentation in the United States where the guardian. So there is no requirement that your guardian has to be a resident, especially if it's not the court appointing that person. If it's you, the juvenile, already staying with that child, or saying I have a sister here or have an aunt here who is ready to take me and who's ready to be my guardian, the court would rather place you in that person's custody rather than just appointing a neutral person for you. So, and the person does not, the court does not go into, hey, are you documented in the United States or not? They don't ask those questions, because if they do that, people won't even come forward. There are a lot of people who won't even come forward to be a guardian to a child if you're asking for that requirement. So there's no requirement of residency. Now, with regards to how long, I haven't come across where, but Miss Epi can correct me, I haven't come across where that has been an issue to say you have to, this person has to be, you must have been staying with this person for a certain duration of time before, you know, this person can be your guardian or custodian. I haven't seen that case. So I don't know if there's anything like that. So and I think the third question you asked, can you please refresh my memory? The third question you asked.
Yeah, can I jump in on the first question before we go to the third one?
Mm-hmm.
So I heard the residency requirement question two different ways. I heard it as, does the person have to be a green card holder, or does the person have to have residency in a particular state? As to whether they have to be a green card holder, no, they can be undocumented. As to whether they have to live in a particular state, yes. You have to be a resident of the state that you're filing in for at least 6 months before you file.
Yeah, that is correct. I was interpreting it with regards to, must you be like a documented resident of the United States? No, that's what I was saying. But you're right about that, because that's logical. For you to be filing for a child to be under your custody in a particular state, you have to be residing in that state.
Yes to all above. The second question was, if the parents are overseas, once the child initiates that SIJS, would that affect their ability to get visas and to be able to come back to the United States?
Okay, I'll say something briefly on that before I pass it to Ms. April. So that, to the best of my knowledge, you cannot say anything. I don't have, there's no how I can say yes or nay to that, because sometimes when, even if it's not for SIJS status, for any other immigration benefit, you find out that sometimes when a family member initiates a particular immigration process here in the US, and then the other family member all of a sudden may be denied visa or be stopped when they go to apply, just because maybe their wife or their spouse has started some form of process here. And you've seen sometimes that sometimes some people are able to just evade that that issue, and it just doesn't bother them. So it would depend on what stage of the process it is, and if it becomes visible to the agency that is dealing with that hey, this person is connected to that person. But I really haven't seen that play out in the cases that I've handled. But that's not to say that that might not be the case. It's possible that sometimes somehow they're able to connect the dot and they see that this aligns or this is this person and they say, hey, no. But sometimes you really can't tell. You really can't determine whether it will stop the person or not. Ms. April, you can chip in.
Yeah, well, typically our bureaucracy doesn't operate with enough efficiency that someone who is reviewing a visa application in the consular office is going to have access to documents filed in state court. we typically don't have that kind of efficiency in people seeing certain things. I would imagine that unless it's a very severe case of something occurring, that they have no reason to go into like an abandonment case. If it's an abuse case where the abuse actually happened and was very severe and there were criminal charges attached, they might know about it. But other than that, you know, I've had clients who are applying for citizenship who had children taken away from them for neglect and placed in foster care, and they still are able to get citizenship. So nobody's going to be able to give you an answer that is a just yes or no on that, because you're just dealing with a lot of bureaucracy and a lot of agencies. I also have an answer that you're not going to like at all, which is, what's more important, your child's future or this adult? What's more important to secure? I personally have a pet peeve about people who see a pathway for their child that is an option for them to become a resident. You made the choice for your child to be here. You have to make the best choices for them. You don't get to just have them here and abandon them and have them be undocumented with no options in life. I know that's not what you want to hear. Nobody likes when I say it. But you have a responsibility to this child that's greater to yourself. And I get annoyed when people make these decisions and then make their children suffer under them because they want to save their own skin. I'm done.
There's another one that says, if you have an asylum case ongoing, though the case has not been heard, can you still file for juvenile status for the child without getting into trouble? I believe so too, especially if that filing for juvenile status is more viable for that child than the asylum. Most of the time when you file asylum, the juvenile is just under the parent. They're not the principal applicant on that asylum. They're probably just there as the derivative applicant. So if he or she has a very viable case of abuse, mistreatment, and abandonment, and you can file for, I believe you can still do that.
Okay, and somebody sent me directly, would filing for this process cause any issues for the parents who are also filing for their citizenship or green card? Most likely no, but it also just depends on the circumstances and the facts. If it's a criminal case, like I said earlier, that led to the abuse, or that the abuse led to a criminal case, then of course those criminal charges are going to have an effect in applying for residency or citizenship. But if it's simple abandonment, probably not. All right. Any other questions? Anybody want to unmute themselves and ask a question, or anybody else want to send a question to the chat? We can wait a few more minutes because I also forgot to explain. Oh no, you did explain that. Okay, we did go over that. Okay, I did hit everything. All right, Benga, I don't think that we have any other questions if you want to close us out.
Okay. We want to thank you, everyone. Most importantly, let's give a virtual round of applause for our amazing attorneys for blessing us with your expertise and time and insight. Thank you very, very much for your support for the community. So this meeting is being recorded. There's some questions coming that I believe already has been answered, so there'll be opportunities for replay. But I want to thank every single one. Every single month we have this Know Your Right workshop series. If there are topics you think we should also cover, you can go ahead and make a suggestion to us. I want to also do a call to action to connect to the Nigerian Center on social media, reach out for volunteer opportunities, community partners, speaking opportunities. July 7th, we have an event about progress report and opportunities to get involved with what we do. You get to meet the rest of our team and also ask more questions to us. And also donation, we also ask for your financial support to continue the work that we do. That being said, thank you everyone, and we are all released into greatness.
Thank you, everybody. Thank you, Ms. Epi. Mr. Benga, thank you.
Thank you
Bye.
all so much. Y'all have a good day.
And you too. Bye.